Hey guys, this is the second video in this series on Shareholders Agreement. Today we're going to talk about typical clauses that you would see at the beginning of a Shareholders Agreement. Okay, so if a company has already been incorporated, that means set up, registered with ACRA, and the shareholders decide to enter into the Shareholders Agreement after incorporation, the first clause of the Shareholders Agreement would typically state something like, as at the date of this agreement, the company has an issued and paid up share capital of $10,000 divided into 10,000 ordinary shares of $1 each. Shareholder B subscribed and holds 6,000 shares. Shareholder A has subscribed for and owns 4,000 shares. For those people who decide to draft a subscription and shareholders agreement, which means the company has not been incorporated yet, the first clause would typically state, the parties shall no later than 30 days from the date of this agreement procure the incorporation in Singapore of a private company limited by shares under the name ABC Private Limited or such other name as may be mutually agreed by the parties and approved by the Registrar of Companies. It will go on to say that the company shall be incorporated with an issued and paid up share capital of $100,000 divided into 100,000 ordinary shares at $1 each, with shareholder B subscribing for this amount of shares, shareholder A subscribing for this amount of shares, shareholder C subscribing for this amount of shares. And then it will go on to say, within 30 days after incorporation of the company, each investor shall make an unconditional application in writing to the company for the allotment to each of them in cash, payable on allotment, for the number of shares set out opposite their respective names at an issue price of $1 for each share, and upon the terms that neither party can withdraw any application so made. There should also be a completion clause for the completion of shares where on completion, share certificates will be issued to the new shareholders, and there has to be board and shareholder resolutions approving the issue and allotment of the shares. And once the share certificates are issued, the shareholder have to pay for the shares by way of check to the company or by way of cashier's order. The shareholders agreement should also ideally contain a post-completion table showing the post-completion shareholding of the company in percentages and by shares and the aggregate shareholding. The next important clause that would typically be found at the start of a shareholders agreement would be the business of the company. You have to provide a brief description on the business activities of the company, and it will also be wise to set out the responsibilities of the different shareholders. For example, shareholder A shall be in charge of the day-to-day operations, shareholder B in charge of finance, shareholder C, business development. The shareholders agreement should also state who is in charge of the day-to-day operations. Is it the managing director, one of the shareholders, the directors? It's also important to state whether major decisions are vested in the managing director or in the board. You can have a list of important decisions to be made by the company that are vested in the managing director, or alternatively only by the board. So thanks for watching part 2 of this series on shareholders agreements. Stay tuned for the later videos.